everyone. Thank you all for joining us for what we hope to be a thoughtful discussion on decisions affecting democracy under the Roberts Court. My name is Harris Brzezowski, and I serve as co-chair of the Albany Law School's chapter of the American Constitution Society. Our chapter, together with our sister chapter from the University of Kentucky, have the distinct honor of hosting a panel of some of the most brilliant minds in constitutional law. We hope that you find this panel to be informative and you all leave with the yearning to learn more about the issues discussed today. We hope you enjoyed today's event, and with that, I'll turn this over to Professor Bonventre.
Hey, well, it's customary to say that we have an exceptional panel, but we really do have an extraordinary panel. And when I looked at the list, I said to myself, boy, what a better court we'd have if we had these individuals instead of some recent appointees. And they're all smiling, so I gather they all agree with me. But anyway, without further ado, let me introduce this panel. First, we have Professor Aziz Huck, and he's the Frank and Bernice Greenberg Professor of Law at the University of Chicago. Looking through his resume, I mean, buried in there is something insignificant, such as he clerked for Justice Ruth Bader Ginsburg. Really, absolutely extraordinary resume, as with regard to all of our panelists. Adam Winkler is the Connell Professor of Law at UCLA. His book, We the Corporations, How American Businesses Won Their Civil Rights, won the Scribes Award. He's among the most cited law professors in court opinions in this country. Geoffrey Stone, Edward Levi Distinguished Service Professor of Law at University of Chicago. He actually was the dean of the University of Chicago, and quite a distinguished one at that. And early on in his career, he clerked for Justice William Brennan. Then Tom Ginsburg, the Leo Spitz Professor of International Law, Ludwig and Hild Wolf Research Scholar and Professor of Political Science at the University of Chicago. His book, Judicial Review in New Democracies, won the Herman Pritchard Award. And those of us who are political scientists know that's one of the most distinguished awards there are given to academics. So let me start right off the bat with Professor Huck. You recently wrote, Democratic Backsliding Under the Roberts Court. Well, the title itself says so much and is so provocative. Would you mind telling us about not only the title, but what you were speaking about in that paper? Go ahead.
Yeah, sure. Thanks very much to Harris for organizing this. And thank you, Vincent, for that very kind introduction. Let me spend maybe 4 minutes laying out a general framework for thinking about the role that the Roberts Court plays in democratic backsliding in the United States. And let me offer to that end a kind of structural framework for thinking about the interaction between law and non-legal forces in the contemporary United States that's driving democratic backsliding. And in so doing, I'm going to draw upon some work that Tom and I have done together. But this is, I think, taking that work and providing it or nesting it more specifically in the US context, and in particular, linking it to the jurisprudence of the Roberts Court. So I would suggest that it's useful to think of the United States and its democracy as facing a series of challenges to democracy that are unfolding in slightly different registers, slightly different timescales. I'd flag 3. First is the challenge posed by undemocratic structures that are built into the national constitution. So the most obvious of these is the Senate, which is becoming increasingly misaligned with the distribution of the American population. The second of these is the rise since the beginning of the 1970s in concentrated wealth and the decoupling of political outcomes or outputs from legislative and regulatory bodies from popular preferences. So wealth is increasing, or wealth concentration is increasing, and the tendency of political bodies to respond only to the wealthy is at the same time increasing but becoming more important. And the third dynamic that I think is a challenge to American democracy is the increase in partisan polarization that's been driven, again, roughly since the beginning of the 1970s, by the reemergence of a particular form of what the political scientist Ashley Jardina calls white identity politics. The observation that I make about the court, and I know that Adam and others are going to speak to campaign finance jurisprudence, and so I won't say anything about that. The observation that I'd make about the court is that we can think about lines of constitutional jurisprudence as linking together these crises, linking together the institutional, the economic, and the social pressures on democracies in ways that exacerbate the crisis. Let me, in 2 sentences, give examples of that, and then I'll close. So one example is, in the last decade, the Supreme Court has reoriented the structure of, or started to reorient the structure of civil society in ways that make it more difficult for some groups rather than others to translate popular support into effective political power. On the one hand, the court, in cases like the Janus decision of 2018, has disabled labor unions. On the other hand, in a series of cases largely decided under the free exercise clause, the court has empowered and facilitated particularly evangelical and Catholic groups that seek to become more involved in public life and to obtain the benefit of state subsidies without complying with limitations that traditionally have accompanied them. This gerrymandering of the landscape of civil society is a way of changing the set of groups that can leverage effective political power. The second form of arbitrage that I'd point to is the way in which, in particular, equal protection doctrine, on the one hand, imposes constraints on minority groups from translating wins in the polls into durable policy, but on the other hand, facilitates, enables, and recognizes Jardina's white identity politics by explicitly picking out victims, quote unquote, of affirmative action as warranting special solicitude as a matter of constitutional law in cases going back to the 1970s. So there are other ways of linking together these 3 crises, but what I'd suggest is that it's useful to think about the role of the court as one of arbitrage, linking together various pressures that currently are imposed on democratic rule in the United States.
Professor Huck, may I just follow up by asking you, when we speak about democracy and democratic government, I gather we're not talking about majority rule. We're not talking about that in particular. We're talking about other concepts of liberty and equality. Is that accurate, or am I misreading it?
The definition of democracy that I would lean on for these purposes, and I'd emphasize that democracy is a contested concept that academics use essentially in different ways as befits their project. The definition that I would lean on draws upon political science work about the institutionalization of uncertainty. The idea that a democracy exists if present power holders cannot reliably predict that they will remain in power, but can expect that they will be subject to removal and rotation in office. And I offer that definition because I think it's useful for the United States, but I flag that it can be implemented by either elections or by sortition methods of the kind that ancient democracies use.
Okay, thank you. Do any of the other panelists want to make a brief remark about what Professor Huck just said? Anyone ready for that? No? All right. Well, Professor Huck mentioned Adam Winkler. So Adam, in your Scribes Award book, We Are Corporations, How American Businesses Won Their Civil Rights, you seem to address the reciprocal impact that corporations and the court have had on one another and on democracy. You want to share some of that with us, please?
Sure. It's a pleasure to be here, and thank you for inviting me to participate in this. And it's a great honor to be on this panel of very esteemed scholars, and happy to just have a small voice in that discussion. So, no, my book, We the Corporations, is really about the growth and rise and success of corporate rights under the Constitution. That is to say, constitutional protections for business corporations. And I think that we can talk about this in terms of a democracy effect, and importantly, that in ways that correspond with what Professor Huck just talked about in terms of civil society, an anti-discrimination effect. And then I'll just mention at the end just some other areas of law that further insulate corporations from democratic oversight. So I say that corporate rights has an effect on democracy, and there are ways in which it is both direct and indirect. The direct effect is that if we think about one of the essential regulations of democracy is how we allow people to participate in election campaigns, really the sort of signature moment of a democratic society. We see that the court has not only rolled back campaign finance reform more generally, making it harder for we the people to control our election and the electoral process, but specifically in the context of corporations too. Of course, I'm sure many of the participants here, certainly all the panelists, and I'm sure many of the people out there in the audience know about Citizens United versus FEC, that case back in 2010, where the Supreme Court said that corporations have the same First Amendment speech rights as ordinary individuals and could use their money like ordinary individuals to spend unlimited amounts on ads intended to influence elections. Of course, the problem with that equivalency is that unlike ordinary people, corporations are fictional entities that are created by, that are enabled by law to raise incredible amounts of money. That's one of the purposes of corporate law, is to allow these entities to raise a tremendous amount of capital and then lock that capital into the corporate form where it can't be taken out. The court has, in cases like Citizens United, given corporations the power to really influence our elections in a rather direct way. Of course, corporations have been influencing democracy since the earliest days of American history. And if we go back to the Gilded Age, we remember the famous political cartoons that show, you know, the massive behemoth trusts overseeing the Senate and suggesting about the power of big corporations and big money on democracy. But for most of American history, the court said that nonetheless, Congress and states could limit corporate money in elections. But what Citizens United does is take that last pillar out and allows corporations not only to continue to influence democracy through just the exertion of political power and access, through lobbying, but also now through funding of campaign ads. So not only does this lead to more corporate money shaping American politics and making it harder for we the people to influence elections in light of that corporate control, but also inhibits popular control over business corporations and over the marketplace, because now corporations have even more power to shape regulation and to shape the law. So that's the democracy effect, but there's also an anti-discrimination effect tying into this notion of civil society. The expansion of corporate rights is coming, developing in a way today to allow more corporations to exempt themselves from the basic anti-discrimination norms that infuse civil society. whether it's Masterpiece Cake Shop, a case where the court held that a corporation, a business corporation that is a bakery, could refuse to provide services for same-sex couples, despite a state law that said that you cannot discriminate on the basis of sexual orientation. That case has, while the case itself was decided on a very fact-specific basis, we see that case having a big consequence on other cases, more cases coming down the pike. The Supreme Court's got another case coming up, it looks like next year, on a web designer. And again, so whereas the court in the civil rights era refused to allow exemptions to anti-discrimination laws, the court in this era is allowing exemptions to anti-discrimination laws. And I think that's going to have a profound effect on our democracy and our sense of inclusion and who's participating. And then finally, quickly, I'll just say that even if we move beyond corporate rights, we can see lots of other areas where the law is developing ways that further insulate corporations from popular oversight. Take, for example, administrative law. Well, when the Supreme Court is making the advances that it's making in administrative law, curtailing the power of administrative agencies to interpret their governing statutes, we're also seeing the effect of that is really to empower corporations. Because while the court says all we're doing is empowering Congress to take the reins on this issue and control it, because of Congress's inability to overcome partisan divides and to regulate in the economy with any sort of significant substantive way, it means that corporations now are only or often only regulated by administrative agency regs. And so when those regs are cut back and curtailed, it's really a way of empowering corporations to further defy public and popular efforts to control corporations and to regulate the marketplace.
Adam, let me follow up by asking, is it more insidious for corporations to be spending on political campaigns than it is for other very, very wealthy individuals to be doing the very same thing? I mean, is one more insidious than the other?
Well, it's a good question. I mean, we could just look at the numbers. Yeah, it might be slightly more problematic in light of the fact that corporations have so much more money. And corporations are involved in every level of American government. You know, Citizens United's not going to have a huge effect on presidential elections, although that has led to more dark money because of the precedent set by Citizens United. But big corporations like Apple that have a ton of money, other corporations that are rolling out big retail stores or whatnot, they're not as interested in trying to influence presidential elections. Where that effect of Citizens United could really be profound is in like local decisions, local government, where local corporations can really effectively outspend everybody else. Now, I think the problem of large individual donors being out there is and being empowered to spend their money in unlimited ways is also, frankly, pretty problematic and also defies the principles of democracy. So I wouldn't necessarily say that the fact that corporations can do it it fundamentally alters the problem that we have of the campaign finance rollback, because the allowance of individuals is certainly another problem that inhibits popular control over the marketplace and over social life more generally. So I don't think it's necessarily different in kind, although there are some issues that arise with it. But both of them are fundamental problems with how the court conceives of democracy and popular control of democracy.
And so I'm just wondering, with regard to wealthy individuals, if that's almost as insidious as corporate spending. What do we do? I mean, do we hope the court adopts something like Scalia's test in Employment Division versus Smith with regard to free exercise of religion? So any otherwise valid law may restrict expressive activities, the spending of wealthy individuals. I mean, I'm just wondering about that, because I'm never really quite sure how, consistent with free expression, how we can limit really wealthy individuals, at least with regard to producing and then distributing political communications. But let me go, if I may, to Dean Stone, because we have for him a much more general question about weighing all these kinds of interests. Like, how does the court deal with all these issues of democratic governance? I mean, what kind of, are we talking legalistic? We talking about practical wisdom? We talking about textualism? I mean, all the things we hear all the time. I mean, what does the court do?
So one of the great challenges, of course, of constitutional law is to figure out how to give content, how to give meaning in concrete disputes to the very vague provisions of the Constitution, particularly those dealing with individual liberties. Congress shall make no law abridging the freedom of speech or of the press. What does that mean? Or unreasonable searches and seizures, or equal protection of the laws. The reality is that most of the relevant terms of the Constitution, particularly those involving individual liberties, are so ambiguous in terms of the text that you can't take them literally, because that would be crazy. And therefore, if you try to give the meaning, you've got to ask, what are you trying to accomplish? What is it you're trying to do in giving meaning to these various provisions? And so what I want to talk a little bit about is what courts should do. What is the approach they should take in trying to give content to these provisions? And one of the lessons that I have learned about this goes back to the original adoption of the Bill of Rights. The original Constitution, of course, did not have a Bill of Rights. And when James Madison sent his draft of the Constitution to Thomas Jefferson, who was then in Paris as the representative of the United States, Jefferson wrote back and said, "This looks terrific, but where's the Bill of Rights?" And Madison wrote back and said, "Look, a Bill of Rights is not going to do any good at all. Realistically, the majority will do whatever they want, and to tell them that they cannot abridge the freedom of speech of the press, or that they cannot engage in reasonable searches and seizures, they will just decide what those things mean, and they will therefore override anything that we have in mind, given the nature of these provisions. So it'll only breed a sense of discontent and disillusion about democracy. So we should just not even create that problem." And Jefferson wrote back and said, "You're forgetting all about courts. One of the reasons courts should have the power to interpret and to enforce these constitutional provisions is precisely to guard against the abuses that are inherent inevitably in democracy, in majoritarianism. Majorities will disregard the interests of those who they either don't care about or those who they're hostile to, and they will simply pass laws that disadvantage them. And they will also manipulate the political process and the electoral process to ensure they stay in power. So you need courts to do these things. You need courts to put a check on the majority." And Madison said, "That's really great." And he then put forward the Bill of Rights and so on. So my own view is that if you ask yourself, what's the right way of interpreting the Constitution, given the ambiguity of the provisions? Is it originalism? Is it textualism? Is it the living Constitution? And so on. I would say that at least in the democracy part of the Constitution, the essential responsibility of the courts is to enforce the Constitution and the guarantees of the Bill of Rights in such a way as to guard against the abuse of democracy, which the framers understood was there. And this was absolutely essential to them. Now, for a long time, this is what the Supreme Court, in fact, did. With decisions like Brown v. Board of Education and Reynolds v. Sims holding as requirement one person, one vote, Mapp and Miranda, Engel v. Vitale, protecting the rights of persons accused of crime, Loving v. Virginia, Roe v. Wade, Obergefell v. Hodges, New York Times v. Sullivan. All these cases and many more are examples of the court essentially taking an aggressive approach to the meaning of the various provisions of the Bill of Rights in order to protect against two evils. One is the indifference of the majority to the interests of the minority, out of either indifference or hostility, and the temptation that the majority inevitably will have to manipulate the political process in order to make sure that they remain in power. And so this very long line of cases was basically designed to do what the framers intended, which was to interpret these provisions with that particular challenge in mind. The Roberts Court has deviated dramatically from that understanding of the role of the Supreme Court in interpreting the Constitution. It is a completely different court from its predecessor. Instead of doing what its predecessors generally did, the justices appointed in relatively recent years by Republican presidents have favored gun rights, favored commercial advertising. In Shelby County, they invalidated a critical provision of the Voting Rights Act. They said, well, gerrymandering is not unconstitutional. The campaign finance laws are basically all unconstitutional. Affirmative action is likely to be unconstitutional, and on and on and on. What they've done is exactly the opposite of what courts were meant to do in order to protect our citizens against the built-in risks and dangers of majoritarian rule. And the question then one might ask is, well, what is their approach? If you look at their decisions in the most controversial and important cases, right, and ask yourself, what explains the results in these cases? It turns out that it's not originalism, because if you try to apply originalism to their decisions, it doesn't work, right? You don't get corporations with First Amendment rights, and you don't get the gun decisions that they come up with, and so on. It's not textualism. It's not the desire to preserve democracy, which I think is the right way to approach it. If you actually go back and look at the most important decisions that they've decided, the best predictor of those results is what is in the interest of the Republican Party. And if you simply would take the issues in those cases and say, what would the Republican Party want? The vast majority of the time, that's how these justices vote. And that's not consistent with any principled approach to constitutional interpretation. And it is, in my view, an abandonment, a betrayal of the responsibility of the justices to interpret the Constitution, not in a politically oriented way, but in a way that is designed to promote and to preserve the fundamental values of democracy.
Thank you, Dean. You know, when I give my talk to either continuing legal education or other talks to the bar or to a group of judges, and I say what you said, that if you look at how these appointees are voting, they're voting just like the Republican Party. We're not talking about judicial activism, restraint, textualism. We're not talking about any of that stuff. We're talking about figure out where Mitch McConnell would want to go. And that's by and large how they're voting. And it's like, what heresy they just it, or they're just shocked. And I say, well, I don't know what fairyland you're living in, but you know, let's be a little realistic. But I want to ask you a question about this. I mean, you certainly clerked for one of those who, in the history of the court, was the most concerned about really taking rights seriously, aggressively enforcing individual liberties. But isn't it a dilemma when you talk about enforcing individual liberties to avoid the abuses of democracy? But on the other hand, you really want to enhance the democratic processes. You want to enhance self-governance. Isn't there always a tension there?
I don't think so, because enhancing democracy in the way I've described it is meant to ensure that it is in fact a democracy. And it's, you know, whether it's getting rid of what, imposing one person, one vote, or guaranteeing individuals the right to vote, or striking down gerrymandering, which courts should do. I think those efforts are not meant to create a bad democracy. They're meant to create a better democracy in the sense that it is more representative of the people, and it addresses the actions of those in power to manipulate the political process by adopting rules that are designed to keep themselves in power and to exclude others. So I think if you look at Brennan's decisions in the sort of democracy side of things, the voting rights and so on, I think you'd find that it was pretty consistently designed to reinforce the values of democracy and to be cautious about the dangers of distortion of democracy. So I don't think there's any inconsistency between those two goals of guaranteeing the rights of the disadvantaged and at the same time improving the democracy and the voting and so on, which also tends to benefit those same people, because the other ones should be excluded from voting.
Right, but of course, many of his opinions were very unpopular, and in fact, his opinions and those who support his opinions in many ways kind of gave rise to, right, Reaganism, right, Nixonianism and Reaganism, right? I mean, I remember going across the cross country and seeing signs, impeach the Supreme Court, you know, when they finally, for the first time in their history, gave a damn about individual rights and liberties.
But you're absolutely right that anti-majoritarian decisions are going to be unpopular by definition. Yeah. And that's the risk the court has to take in order to fulfill its responsibilities. And you know, the Warren Court, for example, handed down a lot of decisions that were very unpopular. They're getting rid of school prayer, for example, and dealing with a lot of the criminal rights that they created. Even Boundary Board of Education, of course, was highly unpopular in parts of the country. But that's the job of the court. It's not to be to make the majority happy all the time. It's to protect against majoritarian abuse. And the question is to do that in a way that doesn't undermine the credibility of the court on the whole. And that's something the justices pay attention to. I mean, one of the reasons, for example, they didn't get to Loving v. Virginia until 13 years after Brown was because they were trying to keep things within certain bounds. So that is a great part of the challenge that the justices have.
Yeah, and when I tell my students about what happened after Brown versus Board of Education, Eisenhower had to send in the troops. It's like, you know, wake up. I mean, the stuff we see today, I mean, how unpopular some things are, the same thing. And then in the 60s, what happened? Bobby Kennedy has to send in the troops because of the civil rights laws. So, you know, welcome to the world, right? Yeah. So Professor Ginsburg, you co-authored with Professor Huck, How to Save a Constitutional Democracy. You want to discuss with us a little bit about the role, and we've been talking about it, of course, all along, the role the Supreme Court has played recently in either saving democracy or doing exactly the opposite. Tom?
Yeah, great question. And thanks to the students for organizing this. It's a pleasure to be here. You know, I think what I'll do is talk just about one particular area that Jeff mentioned, which is voting rights. And it's absolutely critical. You know, the Voting Rights Act is one of the great successful statutes of American history. You went from basically no African-American representation in Congress to 13% today, which is roughly proportionate to the population. And that required, you know, intense work by the courts. And this Supreme Court is in essence been on a kind of sua sponte war against the Voting Rights Act. And that began, of course, with the case of Shelby County in 2013, where the court, and I think it goes to something Jeff was saying, you know, despite all the language about deference to Congress and we don't make the law, they basically treated Congress like an administrative agency. Congress, when it reauthorized the Voting Rights Act, had just adopted the formula for under Section 5 and Section 4, and you know, for the conditions under which a state had to undergo preclearance. And the court just said, no, those states have interests. Their dignity is harmed if we, you know, treat them as having a racist history. And so we're going to just end that formula, or we're not going to accept that formula. And that it's gutted the preclearance regime. And what happened? Over 1,000 different restrictions were put into place after Shelby County. So that's step one. Last year, you had the Brnovich case in Arizona, which involved a measure, of the kind we've seen a lot of. I mean, politicization of election management is extremely intense right now. And that was a case which prevented, the Arizona rules prevented ballot harvesting, as the term goes, which if you think about the geography of Arizona, where I happen to be sitting right now, many of those Native American reservations are extremely, widely dispersed populations. And so the practice is to bring the ballot box, if you will, to the folks. Of course, the state isn't doing that. And so essentially the court upheld the Arizona Republican restrictions on voting in that state. Now, just this month, I guess, we've seen a new blow, which is something that probably may have flown under the radar. But in general, a lot of the action for saving our democracy, for allowing what Aziz called, ruling and being ruled in turn, rotation in office, essentially a lot of the action is now at state Supreme Courts, which do have, in many cases, the authority to interpret their state districting efforts under state constitutional law, and in some cases reject those, where the Supreme Court has just basically stayed out of that completely. If it's a partisan gerrymander, the Supreme Court just won't look at it. So I'll give the example of Wisconsin, where we just had a recent case. Wisconsin was about 50-50 for Trump and Clinton in 2016. It's a purple state. But the state legislature after 2010, actually, after that census, basically redrew the boundaries so that they have about a 2/3 majority of the state assembly and a 1914 advantage in the Senate. And so they basically rigged it. So they will not lose a state election unless, there's massive realignment towards the Democrats. They've locked up power. It's exactly the kind of things we should be concerned with our democracy. Well, in a contentious, now of course we're in this redistricting cycle because of the new census, and the plan which the Wisconsin State Supreme Court, which has a Republican majority, approved, had been authored by the Democratic governor, and the Supreme Court, out of nowhere, basically took an emergency request for a stay and overturned that map, more or less. It basically said, and what did it use? It used the Voting Rights Act. The Democratic governor had said, look, we can come up with a compromise map. It will go from 6 African majority, or probably African-American majority state districts to 7. And that's something we think the VRA requires. And the Supreme Court, like out of nowhere, comes in and says, no. You said VRA. Nope, we're the interpreters of the VRA. You can't use the VRA to expand African-American representation in this context. And so it's a complete reversal, of course, of the intention of the statute, but also just illustrates what Jeff was saying, that they're sort of willing to forego any procedural deference when they have an opportunity to attack this most critical of American statutes. I just want to say one last thing, which is, we're seeing some really nutty stuff going on in some of these state legislatures. For example, here in Arizona, there was a proposal in the assembly that after a presidential election, the state legislature should be able to determine who the electors are, regardless of what the majority voters of the state went for. Obviously that is totally inconsistent with any definition of democracy. It does happen to be consistent with an extremely tortured textualist reading of the Constitution. And so, that's the kind of thing I really worry about. Like, what would the Supreme Court do if one of those statutes passed? They're pushing the envelope. And so it's really, really important to preserve our democracy by getting into the details of these voting rights cases and preserving the ability of elections to actually.
Yeah, Tom, you're in Arizona right now?
Yeah, I happen to be giving a talk here today.
Yeah, good. Years ago, I used to follow the Arizona Supreme Court quite a bit. The Chief Justice was Stanley Feldman, who was just terrific. And they had one of the best courts in the country. But I'm glad you brought up state courts because, for example, one of the areas we really haven't talked about much was gerrymandering I mean, you've got the Pennsylvania court, the Ohio court, you even have the North Carolina court, for crying out loud, right, on remand from the Supreme Court, telling the state legislatures, no, you can't do what you're doing. It's partisan gerrymandering. You are diluting the voting rights of our citizens. And I want to, why, when we talk about all of this, democracy, voting rights, rights in generally, why don't, as constitutional law professors, why don't we talk more about what the individual state courts are doing? They may not be able to do anything about campaign finance, because if they put any restrictions on that, we've got a majority that won't let them. But certainly voting rights, gerrymandering, free press. I mean, the state courts, and many of them, like our own New York Court of Appeals, are so far advanced from the United States Supreme Court on issues, for example, like free press. I mean, why don't we talk more about that in constitutional law? Anyone?
Yeah, let me just say one thing, which is I think you've hit the nail on the head in the sense that this is where the action is going to be for saving our democracy, because the Supreme Court is so skewed. And to me, is getting into a place where it doesn't even, it's squandered a lot of legitimacy by virtue of its, of its actions. So I'll give an example of a state Supreme Court that did do something important, and it actually hurt the Democrats. That's the Maryland state courts, which set aside their extremely partisan gerrymandering. And, I think that's the kind of thing we just need to have other state courts do as well. But of course, they are elected in many states, and a lot of money is now flowing into those elections. They're extremely partisan in some states. And so that's a really tough nut to crack. I guess ultimately what it requires is getting funding for good governance type of candidates to those elections, and not just ceding the territory to partisan hacks, if I can use the term.
Yeah. And of course, Jeff's judge, William Brennan, he was one of the leaders in pushing state courts to go forward. And, remember, as long as you don't violate what my colleagues say is the federal Constitution, you could do whatever you want protecting rights. You want to talk about that, Jeff?
Well, you're right. I mean, Brennan had been a state court judge in New Jersey when he was appointed to the Supreme Court. And during the heyday of what was then regarded as the very conservative Burger Court, which today would be regarded as a very liberal court, Brennan basically wrote an article in a law review, I forget which law review it was, in which he urged state court judges to understand their responsibility to interpret their state constitutions in ways that recognized and protected rights that the Supreme Court was no longer likely to be willing to protect. And again, having been a state court judge, he himself understood the significance of that. And obviously there are limits in what you can do, because some things you might want to do would be a violation, according to the Supreme Court, of the federal Constitution. But there are lots of things that you can do that would not run into that problem. And so he strongly believed that state courts should be more assertive than they had been in protecting individual liberties.
I jump in here. I mean, I think that, just maybe throw a little cold water on the idea that we can rely on state courts, or that state courts are going to be our savior. I mean, the problem with the state courts, and one of the reasons why we don't focus on them so much, is number one, limited reach. The ruling only applies in that particular state. Number two, we also see, because state courts are often justices are often elected by the people or appointed. The other alternative is appointed by the state governor with the approval of the state legislature. You don't see as much difference between the political attitudes that govern the electoral branches in a state and the views of the state Supreme Courts. There are some variation. I don't want to say they're exactly the same, but they tend to go together. And so when you have your 20 states that seem determined, or 25 states that seem determined right now to really curtail voting rights and democracy, I just don't think we're likely to see the state courts of those states come in and consistently read state constitutions broadly in a way that really advances the cause of of democracy. So, I mean, when we think about state court, I mean, it could be that we don't recognize that state courts have been doing all this incredible creative stuff and recognizing new rights and stuff like that, because we just don't look there. I think actually the story is actually the state courts aren't doing a lot of that. There's occasional cases, but it's not a huge phenomenon. We don't have state courts saying you have a fundamental right to healthcare, you have a fundamental right to housing, and because of the constitutional limitations from the First Amendment and the way the court reads campaign finance reform, you can't see state courts really envisioning a democracy that operates on fundamentally different principles than what we get out of the federal Constitution.
Although there are courts such as the Oregon court that won't even consider what the United States Supreme Court is doing unless they absolutely have to. I remember we had a symposium a few years ago, and we had some of the justices from around the country, and there was one from the Oregon Supreme Court. And he said, I don't know what you guys are talking about. We never even consider what the Supreme Court is doing when we decide our cases. But
the legacy of Hans Linde.
Yeah, absolutely. Yeah. So either we're talking about enhancing democracy or backsliding on democracy. What about federalism, Professor Huck? I mean, what about that? I mean, because the Roberts Court hasn't particularly been good about federalism. I mean, we know the mantra, you know, states' rights, we got to respect the states. They don't respect the states at all, right? I mean, if they don't like what the states are doing, they have no hesitation in overruling what the states are doing.
The independent legislature doctrine is an interesting example of federalism doctrine at work, and an interesting example of why you can't ascribe either straightforwardly nationalist or localizing tendencies to particular doctrinal moves. This is the idea that's been mentioned by Tom and has come up in a few dissents or concurrences on orders that are issued in non-oral argument cases from the court, particularly around the 2020 election. The thrust of the idea is that only state legislatures pursuant to Article 1, Section 4 have the authority to make certain election-related decisions. For example, in Arizona, obviously, the measure that Tom referred to is picks up on the idea that the legislature might second guess a slate of presidential electors in the wake of voters casting ballots as such. On the one hand, the independent legislature doctrine looks like it is a pro-federalism, a pro-decentralization doctrine, because it's taking a measure of centralizing authority away from the federal government and vesting a dispersed state-level actor with authority. On the other hand, consistent with what Jeff was saying, the context in which the court is adopting or is moving toward a potential adoption of the state legislature doctrine is a context in which doing so favors a national movement, a national faction, as Madison would have called it, which is the Republican Party. I think that there's very little doubt in the context of the efforts to overturn the outcome of the 2020 election, that were we to see the independent legislature doctrine implemented, it would be as a means toward circumventing the outcome of a legitimate and otherwise generally fair poll that didn't favor the Republican Party. So here, federalism is working not just to facilitate or to empower a particular state-level actor, it's also empowering the agenda of a national level faction. And in that light, I think that we should be careful about thinking of federalism either as a pro or con, but rather be alive to the possibility of coalitions and networks that cross state lines and that vertically enmesh the national and the local government.
But we hear so much about deferring not only to the other branches of the federal government, but deferring to what the states are doing. And yet, if the states do anything to restrict gun rights or campaign finance spending, or they prefer affirmative action, or they impede religious liberty at all, the court, as long as it's a traditional religion that they're impeding, the court has no hesitation whatsoever to jump in. So, I mean, isn't there an extent to which, if the court actually was more willing to defer to the states on some of these issues, it actually would benefit democracy. It actually would benefit our rights. I mean, should we even begin with Michigan versus Long, where, you know, all the judges that gave a damn about states' rights decided they were going to start reviewing and reversing state court decisions, which didn't make it absolutely clear that they were based on their own state law. So anybody want to respond to that? Nobody? I guess it was just hopelessly confusing. So what should the court do? For example, what about the gerrymandering? Let's get to the gerrymandering. Some of these courts, right, these state courts, have actually said that the gerrymandering is too partisan. Should the Supreme Court have adopted some kind of a standard, or really is that just far too elusive? Any of our panelists on that?
Aziz, you first.
I can say something briefly. One of our colleagues, former colleagues at Chicago, Nick Stephanopoulos, offered a measure of how distorting a gerrymander was, given the plaintiff expressed preferences at an earlier election, which he developed out of the work of a political scientist called Eric McGee. That measure, which was called the efficiency gap, provided a pretty clear, certainly not unimpeachable, but relatively reliable, quantifiable measure of distortion in relation to the dynamic of or the dynamics observed at a given election, and was characterized by Chief Justice Roberts during either one or the other. I don't remember which of the cases in which there was an effort to reconsider v. Jubaila as sociological gobbledygook. So I don't think the problem is the absence of attractable standards. Professor Stephanopoulos' standard it's not perfect, but it's a pretty good measure. The problem is that the court is, when confronted with a solution to a problem of its own making, the problem that Justice Scalia identified in Veith as the absence of a tractable standard, just turns its back on it for reasons, well, not actually by giving reasons, but by demeaning and name calling. So it's not, I don't think that you can blame the absence of a standard for doing much actual work in the gerrymandering context.
Would it have been better if litigants had challenged an extremely partisan Democratic gerrymandering? Do you think the court would have been a little more sympathetic to doing something about it in that case? Jeff? I'll just say, I think there was an earlier Maryland gerrymander that was on the table at the time that Rucho was adjudicated. Yeah. So it's not like the court didn't know that. So I don't think it makes a difference. Yeah. All righty. Any final comments by our panelists who've been just absolutely phenomenal? Why don't you start off, Adam? A couple of pearls of wisdom to end this session. It's been great.
Well, you know what, I think at the, we could talk about the Roberts Court and all the things that they're doing to curtail democracy, and it's important to have that conversation. But I also think it's important to start thinking about the next conversation. You know, history changes and it develops, and ideas change and develop, and the current doctrine and the current rules are not the rules that we're going to have to live with forever. And I think one of the things that people who are ACS members or supporters of ACS should be thinking about doing is doing the hard work of coming up with new theories of democracy, new ways of imagining these doctrines, so that in the future, when the personnel on the court changes in a way that's much more hospitable to those who are proponents of democracy and democratic reform, have good doctrines to rely on, good answers to some of these questions, and a reimagined sense of what constitutional doctrine is or can be.
Thank you. Tom, you want to say a few final words?
You know, I just want to say, I think it's really important that what you guys are doing, you know, the future of the democracy is in the hands of the students. Unfortunately, it's not people like us. And so, you know, get engaged, follow this stuff, and get involved in this litigation. It's going to have to be a ground fight to preserve these institutions in an environment where only a quarter of Republicans think that Biden won the election. You know, this is not going to go away magically. It's just going to be a ground.
Jeff?
Well, I agree that it is the generation now in law school that will have an enormous impact on all of this. And it's important that they take it seriously. And I mean, ACS was created in large part to respond to the Federalist Society and to address the issues before the Supreme Court and before the judiciary. And I think it's really important to support the organization and to aggressively worry about your children and what their world is going to be like. And this is a time, I think, that you have to be doing this. The analogy to me would have been when I was in law school, the civil rights movement. And I think it's important that this generation of students take on responsibility for protecting the rights for themselves and for their children, because they're in jeopardy.
Aziz, a couple of last words.
Yeah, I would just say thank you to the organizers and to you, Vincent, because I think this kind of discussion actually exemplifies both what Adam rightly said is necessary and what Jeff and Tom have underscored, which is active and ongoing engagement as lawyers to be, law students, and as citizens, both in the legal challenges and also the practical political challenges of our democracy. They don't just arise every 4 years when there's a presidential election. They're going on all the time around us, and we should not forget it.
Well, thank you very much to the panelists, and it really has been an honor to be with you. What an extraordinary group. And thank you so much to the ACS chapters at Albany and Kentucky for inviting me and to allow me to participate in this. Harris, Julia, you have any last words?
Yeah, I just want to thank all of you for coming out to speak to us. I know it is noon on a Tuesday, but it really does mean a lot to our chapters to have you all speak to us today. Thank you.
Just great. Thank you so much. Really great. All righty. We'll see you now.
Bye.
Keep up the good work.